Decisions, decisions, decisions. After months or maybe even years of being in the criminal justice system, every case comes to a crossroads. And at that crossroads, big decisions have to be made. And they're made by the client. The attorney is there to guide them through it, but ultimately it's the client's decision as to whether to accept a plea agreement or proceed into the unknown territory that we call the jury trial. And so on today's episode of The Lawyer's Lounge, we'll talk about the decision-making process, what goes into it, why you should even consider a plea agreement, and what are the consequences that come with the decision on either side of it. So sit back, relax, and stay tuned for this episode of The Lawyer's Lounge. I'm attorney Keith Johnson. Everyone likes talking about the trials. Just like I said, that's where all the TV shows focus on. The riveting scenes where the witness walks through the door and says something that nobody expected. But most cases resolve in plea agreements. Out of every 100 cases, only 2 go to trial. That's a national average. So what does that tell you? It tells you that the system is designed for resolution. Maybe not quick resolution, but resolution. And so you may think, well, why would I hire a lawyer if I'm going to resolve my case outside of a jury trial? Well, the lawyer is tasked with reviewing the evidence, as we all know, because we talked about that last week. But not only reviewing the evidence, but making some assumptions and some predictions that will guide the client into making what is probably one of the more serious decisions that they'll make in their lives. And so the plea process is one that not too many people talk about. And I want to first start with, why should somebody ever plead guilty? Well, first, the system encourages it. It can't function if everybody has a jury trial. Let me give you an example. So each judge is usually on the bench trying cases about 1 time a month. That doesn't mean every month. Some months, they don't have jury trial. There may not be courtroom space. And on the more serious cases, it may take an entire week to try a murder case, for example, or an assault case, or a child crime. And these judges have 300 to 500 cases that are pending at any given time. It's a revolving door. Because if you think about it, the crime that we see on TV, those cases wind up in our court system. But they don't wind up in our court system quickly. And so the system encourages plea agreements because of the sheer volume of the cases that bottleneck into the court system. So also, you have to keep in mind that prosecutors make offers on cases. They make offers on cases because quite literally, they can't try each and every case as well. There are some cases, the lower level theft cases, the driving under the influence cases, what I would consider the cases where you don't have violence involved. The great majority of those cases do wind up pleading guilty because there's an incentive. Most of the time it's probation. Most of the time it does not require any additional confinement. And so for a lot of people, they want to get in and out of the criminal justice system with as little risk as possible. And as attorneys, we understand that. There are a huge volume of cases, and judges push plea agreements. Not that they do it unethically. I'm not saying that, but definitely they have a vested interest in their calendars, like I stated last week, not being overrun with cases. And so they may hint at the fact that for what is referred to as acceptance of responsibility, your client will receive a better outcome versus if they proceed to trial and they're convicted by a jury. And so those are all factors and those are all things that have to be considered by the client, but first by the attorney, so that we're giving the client the best information possible, because we can't predict the future, but we can tell them about trends. I can tell them, listen, this judge on this drug case, you should be fine. You should be fine. Because I had a case like this 6 months ago and we got a good outcome. The person got a slap on the wrist, and the charges were ultimately dismissed through the First Offender Act, which is something that we have in Georgia. The First Offender Act is a big bargaining tool. What it does is that it allows for the case to be dismissed if the client completes probation without any further issues. So ultimately, the ball is in the client's court as to whether they are going to get back on track, do the right thing, and never look back. If they do, then the case will be dismissed and it won't be a hindrance to them. They won't be a convicted felon. And so, from the system's perspective, they want to make sure that cases are resolved, but ultimately, it's up to the client to determine in what manner the case is resolved. That's why I call it the crossroads, because behind each door are a set of consequences that are hard to predict, especially when you're explaining this to somebody who's never been in these kind of situations. But then on the flip side, you have clients who have been in and out of the justice system, unfortunately. And so sometimes they feel like they know how things work a little bit better than you do. Nobody really wants to admit that, but that's the vibe that some people give off. So at this point in my career, I don't really have a lot of time for that kind of mentality. Because while you may have your own anecdotal experience about how the criminal justice system has worked in the past, you weren't with me, you weren't with this same judge, and this is a totally different time period. And so these have to be honest and trustworthy conversations because decisions are made. And with any relationship, you should aim to what? Communicate. Not just get your point across, but communicate to understand what the other person is trying to say so that we can reach a conclusion that's in the best interest of the client. But ultimately, like I've said before, I'm the pilot. The client is the passenger. It's my responsibility to get the client to where they want to go. What's the destination you want to land this plane on? But you can't tell me how to drive the plane. You just tell me what you want to do. You want to resolve this case? I will negotiate. I will try to be the best negotiator I can be. You want to try this case? Let's do that. I will be the best advocate that I can be. I will be on top of the rules of evidence. I will be on top of these witnesses. I will make sure that my closing argument is as good as it could be. But it's hard to do both. That's why I say we're at a crossroads in this episode, because the decisions that you make will impact you for years to come. And from the prosecutor's point of view, it makes sense to try to make offers on cases. I remember those early days, my 4 years at the DA's office when I was an assistant prosecutor, right out of law school. I'm fresh. I'm wet behind the ears, like they say. And I'm trying to figure out what is a good offer on this case. Like, it was hard for me, I'll be honest with you, to make those offers at first, because to me, a year in jail was a big deal. I mean, can you imagine a whole year in that prison? But for some of my colleagues who were seasoned, who had been prosecutors for a long time, they would throw out 5 to 7 years like nothing. Like we're talking about 5 to 7 minutes. And so it took time to really be able to make offers that were kind of tough offers, because I felt like it was just a little bit much. As I got through things, I began to see that, well, first of all, the offer that you make doesn't have to be accepted. So a lot of times as a prosecutor, you may make an original offer, and that offer is now turned into a counter offer. Just like if you're buying a car. Car might be $30,000. You might want to pay $15,000. Well, now we're going a little bit back and forth. We're trying to negotiate. But the messed up part is that we're negotiating and there's lives on the line. There's freedom on the line. And so that's heavy. And that was difficult for me in those early days. The second thing is that I had to realize is that the parole system has a big impact on how much time a person serves. So that 10-year sentence more than likely is not a 10-year sentence in most cases, unless it's one of the more serious, egregious cases like armed robbery, rape, and murder, where by law, you're required to do each and every day. But for the great majority of cases, you may do a third to 60% of that sentence. So now, as a defense attorney, I factor that in. Not that I can make any promises about what the parole board is going to do, because it's based on my client's behavior if they go to jail. Like, are you going to be caught with a cell phone? Are you going to be caught fighting? Are you going to be doing things that are going to be on your disciplinary record where they may not release you early? Or are you going to be a model inmate and get to that parole point a lot sooner? Those are the conversations that I have. And I know you're not supposed to have a cell phone in jail. I get that. But all I'll say is I understand. I understand. Another thing that prosecutors have to look at is really the strength of their case. Like, nobody likes to lose. And people don't want to admit this because prosecutors are tasked with a term that we call in the law wearing a white hat. They're supposed to be focused only on justice, what happened, what's the truth of the case, not necessarily can I win the case. Now, the defense attorney has a different ethical obligation. Our ethical obligation is not to the truth and not to be like the good guy in the story. I like to think that we are the good guys. But it's more loyalty, devotion, and advocacy on behalf of your client. That's what our core obligation is. And so as prosecutors, you have to look at, can you win the case? And if you can't win the case, can you get some measure of justice or supervision for the family or for the victim that you are representing? And so they have to look and say, well, I've got a shaky witness. I used to have witnesses who you would call them up about what their statement was to the police, a lot of times with our domestic violence cases. And these women would act like you were speaking Latin. They would tell you that it didn't happen. They would tell you that they are not coming to court. And they would act like you were the problem because you calling them about a case that they called the police on. That was one of the most frustrating parts about being a prosecutor, is that many times you felt like sometimes you cared more than the victim of the crime. But your name was associated with the case, so you were ultimately responsible for that. Even if the victims said that they didn't want to prosecute, they don't have that final say. That's something that is factored in, but they can't go up there and drop the charges. And I tell people this, when you get the police involved, it now is not in your hands anymore. They may listen to what you have to say as the victim, but they don't have to do what you have to say. And then as a prosecutor, you have to think about this. What is the impact of a jury trial on the victim in the case? Let's say it's a young person who's been abused. Just sitting up there in front of strangers, a judge, a court reporter, the clerk of court, the bailiffs, 12 jurors, defense attorney team, DA, whole gallery. You're in front of all those people. Say you're 12 years old. You've been abused. Somebody didn't protect you when they should have. As a prosecutor, I would have to weigh if this molester is willing to take 10 years in prison. Is that justice, or is it justice to force this child to go on a witness stand and talk about these horrific events, these life-changing events that they are probably in therapy for in front of a room full of strangers just so I can get 20 years in jail? So you have to listen to your victim. You have to be wise and try to take ego out of it and really think about what is in the best interest of the victim in the case. So that can factor into a plea agreement. Once again, these are not things that are discussed or are part of the plot and the storyline in most crime documentaries, crime shows. But this is the nuts and bolts behind the bar, looking at the criminal justice system. One of the things that we can't control, but a prosecutor will take into consideration, is what is my client's criminal history? And I like to think that all of my clients were choir boys, but they weren't. A lot of them have been in trouble before, and they have these rap sheets or these criminal records that sometimes date back to when they were 15, 16 years old. And so it never goes away. I had a judge who I love to death, Judge Blanchard, would say, Your record is like your shadow on a hot summer day. You can run as fast as you want to. It's still right there. It's never going anywhere. And ultimately, there's a lot of truth to that metaphor because the record remains. That's why the First Offender Act is important, but you only get that one time, one opportunity to get a do-over. And on certain offenses, those really serious violent offenses, you're not even eligible for first offender. And so a prosecutor has to look and say, is this person capable of rehabilitation? I mean, I've seen that they've gotten probation 3 or 4 times, and every time they violated, they were on probation when this happened. I've had cases like that. And so the past has a lot to do with the future when we're talking about what these offers are. And these are all things that as a defense attorney, I can't control that. I can't control what the impact of a trial is to the victim. I can't control the caseload of the prosecutor. I definitely can't control what my client did with their criminal history before they met me or retained my services. But these are all things that factor into what a DA tells me when they pick up the phone and they call me about an offer, or when they email me the offer and I have to relay this news to my client. Because that's when you really feel like you're practicing law. Everything before this is a buildup. Obviously, the crime, the arrest, that first court appearance, and the exchange of information that we talked about last week, the discovery. But when you're at the crossroads, that's when things get real. That's when a picture becomes a lot clearer about what we're up against, but also what your options are. And so prosecutors can get a bad rap. Sometimes people think, well, that offer is too tough. According to who? Sometimes people can think that the offer is too light. Well, you don't know the strength of this person's case. It might not be as strong as you think it is from the headlines. Because keep in mind, the police have a police report, and that police report has a summary of the witness statements. But I have seen a lot of trials in my life, and never is the statement or the recorded statement or the summary the same as when a person has to come on a witness stand, be placed under oath, and be asked questions, first by the prosecutor, but then those more difficult questions by the defense attorney, which we refer to as cross-examination. So a prosecutor may know this witness is not going to do well. They are going to fold, they are not going to remember, and they're going to start agreeing with the defense attorney. And so that may factor in as to why they make an offer that may seem a little bit soft. It's about risk management. Maybe I can get this person on some supervision by the state so we can ensure that there are not more victims, or we can ensure that they get on the right road versus risking an acquittal. So let's go to the other side of the room where you sit at my table, the defense attorney table. So a lot of times we're receiving the offer first. Now, I do have a limited number of situations where time is of the essence. My client knows that they may have to accept some kind of deal. And so now they authorize me to be the aggressive one in reaching out to the DA and saying, listen, my client will accept 3 years probation in exchange for this case being resolved in the next 30 days. Or sometimes if my client is already in custody and they've already done a lot of time in jail awaiting the trial, then I may say, listen, let's resolve the case with 2 years in jail with credit for time served and maybe some probation on the back end of that sentence. That's not always a bad option. So everything depends. And I know people don't want to hear that, but the law is about the gray areas. If everything was black and white, it would be a formula. It would be 1 + 1 = 2. And then anybody could do it. And I mean anybody. So what makes it an art form is that it really does matter who you hire. It really does matter what the situations are. It really does matter which judge you're in front of. So those who want the law to be uniform, I understand that. I just want it to be fair. Because as an advocate, I don't want everybody to get the same outcome that I worked hard to get. Because then, where's my value? You could just stick anybody in there and they would get the same outcome. So when somebody hires a lawyer, I always tell them you are inheriting the reputation of that lawyer. See, when you walk into that courtroom with that attorney and you're standing up there in front of that judge, you are standing beside somebody that that judge knows and has been in front of a lot of times. That prosecutor may have dealt with that attorney or at least heard about the attorney, know their work ethic, know their results. And so if you are known to be willing to try a case, whether you win or lose, you are a warrior. Prosecutors take notice of that. I used to take notice of that. When I was a prosecutor, I knew which lawyers were not going to try that case. I knew which lawyers were going to call me on Friday before the Monday of trial and beg for a deal. I knew that. Everybody knew that. It's not a secret. But you don't want to be one of those defense attorneys. That's nobody's goal. Now, it takes hard work to prepare for a trial. It's like a big examination, but you have to be willing to do that work so that you can get good offers. And so I think about things like, what's the maximum that my client could get if this case is lost? Nobody wants to think about losing. And I've had clients who get upset when I talk about the possibility of losing, but I don't really care about that. Because while we don't lose a lot, you have to factor in that this is not guaranteed. It's never guaranteed. It's always a crapshoot because we have 12 strangers that we don't know from the community who are judging this case and who are making a decision. So we have to think about what's the worst case scenario, because unfortunately there can be a trial tax. And I don't agree with a trial tax. I don't think that you should be penalized for exercising your constitutional right to a jury trial. But I would be lying to you if I told you that it didn't happen. I've seen it countless times in my career where judges give people the maximum because they've lost at a trial. And when I say maximum, I mean if an armed robbery is 10 years, because it is in the state of Georgia, mandatory minimum every day of 10 years. But the maximum is life. I've seen young people go to trial with lawyers who were not skilled, who were not prepared, who did not stay up all night getting ready for this case. I've seen those young people lose cases and get life in prison. And in the state of Georgia, life in prison is 30 years before they even look at your file for parole. And after that, you're eligible for parole every 2 years, but it's not a guarantee. So those are things that have to be considered when you roll in the dice, because that's what I say that you're doing. You're rolling the dice. You also have to look at the strength of the case, not just the potential penalty, but let's dig into it. What is this witness going to say? How can we refute that? What's the credibility of the witnesses? What's my client's credibility? Can my client get on a witness stand and testify truthfully and keep their composure? I talk a lot to my clients about keeping that poker face because people are judging your facial reactions. They are judging your body language and your demeanor when certain items of evidence are spoken about in a trial. Do you drop your head? Well, that may be a sign of guilt. You may not even think about it like that. How many times in your life have you had to hear people talking about you and not in a good way, and you are privy to that? You hear it and you can't respond. That doesn't happen a lot. Most of the time, you're able to respond, and most of the time, it's a reaction, not a response, right? I've been guilty of that too. But the crazy thing about a jury trial that you have to consider before we even get to the jury trial, because that's next week, but I have to see, can my client really sit there and be a gentleman while people are talking crazy about what he or she did? Can my client get on a witness stand and face tough questions without getting an attitude or getting short or rolling their eyes or sucking their teeth? Because those are human reactions. I'm not here to judge that reaction. But in a courtroom, I got to be able to know that I can trust you, that you're not going to torpedo your case while you're on the witness stand or sitting at that defense table. We don't want to see any smirks. Nothing is funny. But there are people who have a nervous laugh. You may not think about stuff like that, but I have to when I am trying to determine and talk my client into whether or not they should go forward with a jury trial. Some of the other things that I think about are what county or what jurisdiction am I trying the case? Am I trying it in a more rural place? Am I trying it in a more urban center? Am I trying this in federal court? Am I trying this in superior court? Because all those are factors that uh, build into what kind of jury am I going to get? Are they going to be more sympathetic? Are they going to be older? Are they going to see my client as somebody who is like a grandson or somebody who is like a coworker? Or are they going to see my client as somebody who's dangerous, who is sitting over there at that table because they must have done something wrong? Because if we have a jurisdiction where it's a lot of pro law enforcement jurors, it's a lot of that back to blue stickers on the car, it's a lot of that conservatism where you think that the police just don't do anything wrong, then that might not be an appropriate forum to roll the dice. And I've been in those counties, in those situations where you don't feel like you might not be getting the very best shot. And I have to tell a client that I don't take any pleasure in telling that. I actually feel really bad because we've dedicated our lives to being in the justice system. So I want to tell people that it's fair regardless of where you get in trouble at. Well, that'll be a lie. And I'm not in the business of lying to people. So I have to look at what are the likelihood that I can get jurors who relate to me. Maybe they go to my church. I like to get my aunties on the jury. Shout out to my aunties. I say my aunties are my women from the ages of, no offense, like 45 to 70. Like they have some life experience. They might see my client as somebody who might have been in a little bit of trouble, but just a knucklehead. And we are not about to send this little boy or this young man down the road for 20 years for some foolishness. They want the prosecutor to prove their case because they know sometimes the police can be a little bit aggressive when they come up in the hood. See, those are jurors that I want that have some life experience. I don't want nobody that thinks that life is black and white because it ain't. I want people who are going to think and who are going to hold a state accountable to their burden of proof. And so every case becomes a calculated risk, not just an assessment of the law and the facts, but a calculated risk. And I always ask my client this: if we get the worst possible scenario, you are convicted, can you live with it? If you can't live with that, what that maximum might be or what that double the time might be, then we need to resolve this case. Not that we go into it with any fear, but you have to go into it with your eyes wide open, because I will not and I cannot accept somebody saying that, man, my lawyer didn't even talk to me about this. He just sold me all these rose-colored glasses, and I looked through them, and I didn't really appreciate the fact that I had the odds stacked against me. They might say it, but it won't be the truth, because we want to go through each and every element of the crime, each and every scenario, so that we can make the best possible decision. And the third part of the perspective is not just the prosecutor, not just the defense attorney, but the client perspective. Because ultimately, like I said, they have to make the decision of their life. And in those decisions, they have to really be level headed and objective. So there has to be trust. And a lot of times, the trust is tested during this time period. Because in my experience, when you start talking about why a client might need to plead guilty, oh man, those defensive mechanisms just raise up, even subconsciously. I mean, people that you thought you was cool with, you start talking about, yeah, you might want to resolve the case with a plea. A plea? I ain't pay you for no plea. I've had that so many times, man. And I just tell them, listen, man, I'm a trial dog. All right. Like, I fight. This is what I do. I'm a practitioner, man. I ain't scared. That's why you called me. I didn't call you. You called me. But I also only go to war if we can't find peace. I don't just do it just to do an experiment with your life and with your case. This is not a law school exam. But people do tend to get offended if they believe that you're saying that you don't think that they can win at trial. And I've had people try to talk me out of things. And I tell them, listen, this is your decision, but you need to trust me and you need to trust that I'm telling you sober minded advice because ultimately I want you to get the best outcome on your case. And so they ask questions like, what should I do? Can we win? They ask questions like, what happens if we lose? And then that's when I have to tell them those things. But I have to be honest, man. Some of the biggest cases that I've won and been known for have been those cases where I had the most stubborn clients. I mean, these guys made me mad because they would not accept the plea. And I just knew they was going to get convicted. Let me tell you about one. We'll call him Dre. Dre had, this was in 2021, he had 9 counts of aggravated assault. Dre was a drug dealer. And he got into a dispute in a section of Augusta called Harrisburg. And during that dispute, he's firing shots. Totally dangerous, totally uncalled for, in the middle of the neighborhood. He's shooting back and forth with this other guy. People identify him because he's from the area. People identify him and they say Dre was the one that was shooting. Well, Dre has a rap sheet as long as the Old Testament. The boy been getting in trouble forever. At this point, he's in his 40s, but he's been getting in trouble since he was about 15, in and out of prison. Now, Dre knows that the phones at the jail are recorded. Do you think Dre is talking cautiously? Nope. When he gets picked up, he calls his girlfriend and he says, yeah, I shot him and I offered him $10,000 because they had been looking for Dre. I offered him $10,000 not to show up to court, man. That dude didn't even take the money, man. All I wanted him to do was take the money. Then he proceeds to say, but you need to call Keith Johnson. He's the only one that can free me. I have the recording on my phone now. We might even add it into the episode at the end just so you can hear, okay? Because this is crazy. So he's saying, you need to call Keith Johnson. And so his significant other, she's flustered. She's not into this life. She's like, what do I need to do? She said, call Keith. He can free me.
We got to figure out a way to get that Keith Johnson paid. You hear me? I don't give a fuck. We'll give him $100 every 2 weeks. $150 every 2 weeks. You feel what I'm saying? But listen, this is what we're going to have to do. This is the only way I see I'm gonna shake free from this.
Yeah, I know with a lawyer.
Him. He the only one that's going to free me.
And they played that recording in court. I knew they were going to play it in court. Now, if you're on the jury, what would you think? You would think this dude is guilty. He is talking about paying off the victim. There are people who say that was him shooting. He is on the jail call saying, you got to get me this lawyer because he's the only one that can free me. And Dre got acquitted of all 9 charges. Like, they walked him. And to this day, the judge jokes with me about that case. He said, I don't know how you did it, but I ain't never seen nothing like it. And I don't say that to boast or nothing like that. That's a true story. That happened in July of 2021. Right after the second COVID wave. I remember that. And so it was one of those situations where no way possible should Dre have taken that case to a jury trial. But I believe I had some aunties on that jury that knew that the other guy wasn't all the way in the right either, and that Dre could have been a victim just as well as a defendant. And they were just tired of the foolishness, and they knew that if we convict this fella of 9 counts of aggravated assault, he ain't never coming home because each count carries 20 years. And the judge probably would have given him a consecutive sentence because he had been a career menace. And so Dre was fortunate enough to get his life given back to him. Unfortunately, he got back in trouble. And I walked into court 2 months ago, and I saw on the screen that he was on the screen at a correctional facility in South Georgia entering a not guilty plea to a new case that he had. Man, it's sad. Like I said, the podcast is going to be real. I'm not telling you any rosy stories that he's out here reading books to kids, because he's not. But there was a situation where he shouldn't have gone to trial. He got blessed, and I saw something in court that was fascinating. It was a blessing, but he just didn't take advantage of it. Then I have another client. We'll call him PJ. This was back in 2018. PJ was messing with a female that ultimately accused him of sexual assault. Now, according to PJ, this girl just got mad at him when she found out that she wasn't the only one. She got a rape kit done. And we were able to negotiate the case because he was charged with a very heinous act. And PJ was soft as a teddy bear. So I had questions about her story to begin with. Not that I don't believe victims. All right, we're not trying to go viral. But also, I do know that every case has to be tested because of the penalty on those kind of charges. And so in this case, PJ would not accept the deal. He kept telling me that the Lord told him not to take a deal. And I told PJ, man, listen, I grew up in the church, man. I got baptized when I was 11, man. My dad was a deacon, man. My mama took me to church every week. That's one of my favorite things to talk about. But I do know that the good Lord has given us a mind, and he gave us lawyers who go to school. And so I really don't like to hear when people tell me that, well, God told me this and that. Well, we go to trial, and I am cussing under my breath. I am not happy about this because I don't want to see PJ get a life sentence. He was in the Navy. He got kicked out of the Navy because of the allegation. And so he's kind of working at Waffle House, living with his mom, kind of pitiful. And my thing was, PJ, they offered you 10. We're looking at 25 to life with no parole. On this 10, you might do 6. I know it's 6 years, man, but there's DNA. Your DNA is in a place where the DNA shouldn't be. No, I'm not taking the deal. I'm believing in God. I said, PJ, all right, sign this right here. And I got him to sign a statement saying, my lawyer has advised me of what the penalty is. My lawyer has told me that I can be convicted based on the facts of this case. And I am declining my lawyer's advice, and I'm proceeding to trial knowing the consequences. I covered my you-know-what because I didn't feel good about this. I had just opened up my own solo practice. The jury acquitted PJ. They acquitted that joker. And I was shocked. I'm still kind of shocked talking about it, to be honest with you. I don't have any punchy line to say other than they didn't believe her story and they didn't believe the DNA. They thought it was consensual. There were elements of the case that led them to believe that it was consensual. And he got his life back. I saw a man believe more than I believed in him. And so those are two clients who bucked my advice and got a good outcome on the case and are now a part of my war stories that I tell people. The last of the bunch recently passed away. But I tried his case last year, and he was charged with armed robbery, ag assault, and home invasion. And I remember him telling me, man, Keith, you the GOAT. You like LeBron James, man. I ain't hire you to take no plea. Now, if I would have known that when his mama hired me, I might not have took the case. Because I don't take these cases promising a jury trial because it might not be in your best interest. And he had a witness who was going to identify him. He had a witness who was going to say that I know him because I knew him from prison. He said, I don't care about that. I got you. I've been praying about this. I want to go to trial because doing another 3 years is the same as doing a life sentence. I said, what are you talking about? That makes no sense at all. You mean to tell me that you got children out here in this world and you are willing to risk the rest of your life in jail because you don't want to do another 3 years? You've already done 3 while we were waiting for it to get to a jury trial because the judge saw your record and he said, I'm not going to let you out. Plus, these allegations are serious. We faced a judge that, quite frankly, was prosecution friendly. He walked. The jury acquitted him in less than an hour, even with the person sitting on the witness stand identifying him and saying, he is the person who pistol whipped me. He's the person who took my money. We won the case. He believed more than I believed. I was kicking and screaming going into that courtroom. Man, I don't want to see no car wreck. I don't want to see you get 100 years, because this judge was going to give him 100 years and was going to go out to lunch afterwards and not think twice about it. And I knew that. But I said, you know what? This what you want. This what you going to get. And so I went in there a little freer, right? Because I've had clients tell me, whatever, Key, we'll just crash out in court. And I said, whoa, crash out. Man, I ain't trying to crash out. But that's the lingo. And so those are 3 examples, 3 recent examples in my career where people have bucked my advice. So the client ultimately can do what they want. Now, I've had clients who have elected to go to trial, and I've withdrawn from the case because the attorney-client relationship was fractured. There was now a lack of trust. The examples I just gave you, I was just annoyed with them. I still wanted to defend them. They still trusted me and my skills. They just were willing to roll the dice with their freedom in a way that most people are not. I don't know what is inside of a person to make them that confident when the justice system is staring at them in the face. And there's an alternative. There's a side door. But in the great majority of examples, people do elect to take a plea agreement because it's scary to go up there and have your life flash in front of your eyes and have some strangers sitting back there in a room weighing the scales of justice. So those hard conversations have to be made as a defense attorney. You cannot shrink from your responsibility. Just like I've always said, if I wanted people to like me, if I wanted to have an easy road, I'd go out here and sell some ice cream in the summertime, because ain't nobody mad at ice cream, man. But I'm a defense attorney, man. And that means that I got to tell people bad stuff. Just like I say, I'm like the oncologist sometimes. I'm going to tell you what you got. I didn't give it to you, but I'm trying to help you. I'm trying to get you to a better place in your life. I have to talk about the uncertainty because that's part of all of what we have to do, especially as we're at the crossroads and we have to make these decisions that have implications and consequences for the rest of your natural life. That's what makes this an exciting job, a hard job, one that's noteworthy, but one that's worth every bit of my stress and frustration. One of the last things I want to talk about is the misconception of plea agreements. You know, you'll hear people say, man, my lawyer made me take that deal. Don't believe that. Like I said, now you're educated. You know this. You know more than the average person because you've been rocking with us for the past several weeks. The lawyer cannot make the client do anything. See, when we get up in front of that judge at a sentencing hearing or right before a trial, the judge will say, do you wish to proceed to trial? What is the offer, Mr. Prosecutor or Mrs. Prosecutor? And the prosecutor will say, we have offered to reduce count 1 to fill in the blank with a potential sentencing range of fill in the blank. This offer was made on this day. And it's my understanding that the defendant wishes to proceed forward with trial and does not wish to accept the offer. The judge will say, Mr. Johnson, is that correct? I look at my client. My client will answer the question. So we're all on the same page. If the client is at a sentencing hearing, the judge will say, you got a right to a trial now. And at that trial, you don't have burden of proof. They have to prove it against you. You have a right to bring in your own witnesses and confront their witnesses. And if you don't testify, that's fine. We're going to tell the jury that you don't have to testify. And at the conclusion of the case, you are presumed to be innocent, and the state has the burden of proof. You don't have to plead guilty today. You don't have to resolve your case like this. You can make them prove it. So do you want to waive those rights and be sentenced? And the client has to say, yes, I don't want to go through that process. I would rather plead guilty and accept my fate. So nobody makes anybody do anything. So next time you hear something like that, well, man, my lawyer made me do it. No, your lawyer didn't make you do anything. You did it because you felt like it was in your best interest. Now, you might have had some weak lawyering. You might not have had a lawyer that was going to look under every stone. You might have had a lawyer that had a reputation for being weak. But the judge still has to ask, is this what you want to do? So that's why it matters who you hire. That's why it matters the relationship that that person has with the court system. Because your name and your reputation as a lawyer are all you have. Has anybody ever thought about why the law firms put their name on the side of their building? The name on the business card, right? We don't have the criminal defense firm of Atlanta, Georgia. We don't have the criminal defense firm of Miami, Florida. No, you have Johnson and Sons or Johnson and Tucker or the Keith B. Johnson law firm. You have things like that because your name is the most important thing that you have. Your name lets people know who they're dealing with. So as an attorney, that's the most important thing that you carry into a courtroom. And you try to protect that by doing good work for people, even if they get an outcome that is unfortunate. Because our job is to make sure that the process was thorough and that people were given a shot. And so that's what this episode was about. Being at the crossroads, making that one final decision as we cut off the other options and barrel right into a jury trial. And we're almost there. We're almost at the point where we can sit back and talk about the most important part, what I believe, of the criminal justice system. It's the right to defend yourself. It's what separates our country from a lot of other countries. I know it's not perfect, far from perfect, but it's damn good. And so on next week's episode, we'll talk about that jury trial. We'll talk about the feelings that come with that. We'll talk about the surprises that are ultimately in each and every trial. It never plays out how you think it's going to play out. We'll talk about the highs and lows, and I'll share a few war stories, some behind-the-scenes stuff about what really goes on inside the bar when you have a person's life in your hands and you have people coming into your office, which is the courtroom, to watch you work. As always, the past is behind you. There's nothing you can do about that. It's informative. If you have to look back, let it be looking back knowing that whatever was thrown at you, you faced it. And what didn't kill you only made you stronger. The future belongs to the good Lord. It's the unknown. It is what we don't know, what we might think we know, what we might anticipate, but it's still not the present. The present is where all the magic happens, where we should put our trust and our faith, because you can control the things that are within your grasp and leave the rest to the good Lord. Until next time, salute.